All rise.
Hearing in the appeal, Bissonauth and the Sugar Insurance Fund Board.
Good morning,
Good morning.
my lords.
I had, I'm afraid, understood that both advocates would be addressing us from Mauritius, but it's extremely good to see you here. Are you for the appellant?
I appeal for appellate.
Then your name is Mr. Tiluk Dari. Well, you're very welcome. And let's just address Mr. Persem. Mr. Persem, good afternoon.
Good afternoon, Lord. I should say good morning to you.
It's good morning for us, but good afternoon for you. And
Thank
I
you.
hope you can hear and see everything that's going on. And if you are in any way concerned that you cannot hear everything that's said and see everything relevant, please put up your hand and we will address your concern.
Thank you, my Lord. I can assure you that as matters stand, I can hear you very well. I can also see you. For the record, I am appearing with my friend Bilshan Simulu. I believe my instructing solicitor would have informed your lordship that Mr. Simulu is appearing with me. Thank you.
We've got his name on our papers, and we're very grateful to him for assisting you. So
Thank you,
we will now begin the hearing with Mr. Tiluk Dari addressing us about the merits of the appeal.
My lords, I appear for appellate with my friend Gudari, instructed by Mr. Robin Lloyds of Axiom Stone Solicitors. Respondent is represented by my learned friends Persam and Nursimulu, instructed by Mr. David Miles.
Yes, thank you.
My lords, before I start, my usual apology for the state of the record. We have an updated electronic copy.
There were one or two errors in the original record. Somebody had copied the odd pages and not the even pages of an important transcript, but that was spotted and has been rectified, and I'm not sure we've got many continuing criticisms of the record.
The electronic record is almost complete. It ends with page 1042. There is an additional supplementary bundle that has been put in.
Yes.
Containing 3 documents. Applicant's affidavit dated 12th of November 2015.
Yes.
Where tab 3 was missing in the original record. And then the proceedings of the Supreme Court dated the 3rd of October 2012, and the application for warrant of seizure dated October 2012.
Could you pause, please, Mr. Tiluk Dari, while I inquire of Mr. Persem whether he and Mr. Nursimulu have the supplementary bundle?
My Lord, I am informed by my junior friend that we have indeed received the additional bundle.
Good, thank you. And Mr. Tiluk Dari, speak up as much as you can.
Yes, my lords. I take note. My
Very
lords,
well.
the warrant of seizure contained, amongst other things, document relating to the former appeal.
Yes.
That is, the application for conditional leave, an affidavit dated the 15th of January 2003.
What page number in the supplementary bundle is that?
It would be page 29 onwards.
Thank you.
Yes. My lords, my lady.
Yes, we've been looking at that in particular, Mr. Tiluk Dari, in order to better to understand what the issue was. when the appeal actually arrived before the Privy Council in 2007. And we've been looking at the application for leave, and in that, it may have been drafted by you, I don't know, but in that, various points were raised about the quantification of your damages. But at the moment, it seems clear to us that by the time of the hearing before the Privy Council, there was only one issue pressed.
Yes, ma'am.
Namely the issue of whether the dismissal had been perpetrated in such circumstances that you were entitled to punitive rate.
Yes, ma'am.
And we all know that on that one issue, you succeeded.
Yes.
Very well.
My lords, this appeal is an uncommon one. My client, the appellant, is coming before this board for the second time. He was successful in 2007, and it is humbly submitted that to understand the issue which is before the board today, one has to go back to the chronology of events. Appellant was dismissed from employment 20 years ago without any hearing and without any compensation for an incident which occurred 5 years earlier on the 28th of December 1991, which incident was qualified as a work-unrelated incident which occurred on a non-working day, some 11 to 12 miles away from appellant's workplace. Appellant spent 11 years in obtaining victory before the board. He went before the Industrial Court in January 1997 and lodged a claim for unjustified dismissal. The plaint before the Industrial Court is quite explicit, where he computed what would be his remuneration, what were his entitlements, and the sum claim amounted to roughly 4.2 million rupees plus interests as per the Labour Act. The respondent was unwilling to pay any compensation. They filed their plea in April 1997 to say that no sum whatsoever is due. My client lost before the Industrial Court in July 2001. He appealed to the Supreme Court. In December 2002, the Supreme Court partly allowed his appeal. My client was aggrieved with the judgment of the Supreme Court of 2002. He applied for conditional leave to appeal to the board. And in his conditional leave application, he contested the figures of the Supreme Court regarding remuneration, his entitlements, and he also claimed interests, which was not awarded by the Supreme Court. And I must pause here to say, I am not painting a completely dark picture of the respondent, because the only application that the respondent did not object was the application for conditional leave. And there was no proviso whatsoever that they are not making any admission regarding the averments contained in the affidavit. Same stood unrebutted. My client was granted conditional leave. His appeal was listed in December 2003 before the board. Unfortunately, my client could not enlist legal representation, his appeal was dismissed for want of prosecution. He wanted to restore his appeal. There were exchanges between solicitors on both sides. Respondent solicitor demanded an exorbitant amount of surety to the tune of £30,000 to restore the appeal in 2005. But the board, in its wisdom, restored the appeal unconditionally, which was heard and which was allowed in all circumstances on the 19th of March 2007. Now, what one has to understand by the word appeal allowed in all circumstances. Was the board minded to put an end to the ordeal of the appellant? Was it meant to be a final judgment? And it is one of the issues which I intend to address your lordships and your ladyship.
Mr. Tiluk Dari, do we have a copy of the Privy Council's order of the 19th of March, as opposed to its judgment?
We have the judgment and we have a copy of the sealed order. And
is it in the bundle?
It is in the bundle.
At what page number, please?
Yes. Your lordships will bear with me. At page 143, my lords.
I didn't hear that. Page
143.
143, thank you very much. I asked to see that because the board might have been interested to see whether there was any elaboration in the actual order of what was being allowed. But it doesn't add anything to the judgment.
Yes, ma'am.
So we've got to go back and read the judgment. You needn't read it to us.
Yes,
we've read it carefully. And Mr. Tiluk Dari, you've got to deal with the argument that whatever your notice of appeal to the Privy Council may have said, by the time of the hearing, there was but one issue.
Yes, madam.
Namely, unjustified dismissal plus punitive rate.
Yes.
And of course, you achieved a great success on that.
Yes, madam.
But insofar as your notice of appeal to the Privy Council had raised other issues, like housing loan, things like that, they do not appear at the hearing to have been pressed, and therefore they do not appear to have been addressed. And the argument goes against you that in those circumstances you cannot say that the Supreme Court's earlier decision on those matters was set aside. You've got to deal with that, and it might be convenient for you to do so sooner rather than later.
My lord, I pose here before I complete the introduction. What the board intended to say by saying the appeal was allowed in all circumstances in paragraph 36. Appellant goes before the industrial court. He claims 4.2 million. He makes a calculation. The calculation is registered, the plea. It is denied. He goes to the Supreme Court. He is awarded partly of what he claimed. And the Supreme Court erred on a fundamental issue regarding the obligation on the respondent to afford him a fair hearing. Now, before this board, On this substantial issue, when the appeal has been allowed, it is our respectful submission that appellant won along all the lines.
Could you just repeat that? He won on all the lines?
Appellant won along all the lines.
On all
That
the
is,
lines?
as per his plea before the industrial court. Because nowhere we can see in the judgment of the Supreme Court of the Privy Council dated the 19th of March 2007, nowhere can we see that they have said save and accept or any proviso or any saving clause that part of the judgment of the Supreme Court has been saved. We have no such pronouncement, nor did the board intended to send back the matter before the Supreme Court. There was no direction to remit the matter before the Supreme Court. We usually have appeals where the board set issues before the Supreme Court to reconsider. And during my submissions, I will refer to Lord Matadin's remarks in the case of Pandey. And as far back as I understand, it was in 1987, my late friend Olivry appeared in a case Ali Rasoul, and he was told to canvass those issues before the Supreme Court and to come back. But here we have no such direction, and it is my respectful submission that in 2007, Lord Neuberger, whilst delivering judgment, wanted to put an end to the ordeal of 11 years of the appellant and allowed the appeal in all circumstances. Now, what a layperson like my client understands by in all circumstances, he put in an affidavit where he put in a page of Oxford Dictionary, where it has been mentioned that in all circumstances, in plural, would mean finances, monies.
Could you help me just to understand the Privy Council's judgment, please? Would you mind going with me back to paragraph 10 of it and the immediately following paragraphs, please? Page 14 of the record.
Yes, my lord.
We can see what the Supreme Court determined, 3 months' salary in lieu of notice, but not severance pay, housing loan, etc. And I think we've got that at page 35 of the record, the actual determination of the Supreme Court, haven't we?
Beg your pardon, my lady.
Yes, I think there's some nodding going on the screen, but it's page 35 where the Supreme Court decided that. That doesn't matter really for present purposes, but...
Yes.
Okay. And then at paragraph 12, Lord Neuberger says, other points were raised, but that only one contention was pursued, and that's the question of whether he should have been given an opportunity to answer the charges and so on, and that's the one that he won.
Yes.
But then if you look at 13, I think we can see that that was the only point which the Privy Council thought was being pursued, because he says now that it's been shorn of the other arguments, the case is plain. So the Privy Council doesn't seem to have thought it was being asked to reconsider what the Supreme Court had decided about the other issues, the ones at the end of paragraph 10.
Milady, it would appear that the appeal for us has been allowed on a substantial point of law, that is denial of the right to a fair hearing, to a hearing. And if one succeeds on a substantial point of law, the board would not be interested to go on other minor issues, so that the computation that has been elaborated by the appellate in the plate before the industrial court and has been awarded when the Privy Council says appeal allowed in all circumstances.
Mr. Tiluk Dare, were you the victorious advocate before the board in 2007?
It's my learned friend Alan Newman With whom
Mr.
I had-
Newman.
Yes.
Yes.
With whom I'd had the good fortune in working in 2003, where we were victorious.
Yes, thank you.
Now, and the more so, to support this argument, my lady, if I may, before coming before the board, there was the application for conditional leave and the affidavit that was put in 2003, I understand, January 2003. And the appellate disagreed with the figures of the Supreme Court regarding continuous employment. And these issues, if I may be allowed at a later stage regarding the computation, whether we take the figure of 322 months when appellate went for study with consent of the respondent, or whether his employment was disrupted. And on this only issue, the magistrate of the industrial court was right, continuous employment. Now, regarding remuneration, we have put in some authorities to say that remuneration does not only include salary, but include all the entitlements. Now, the Supreme Court, when it delivered judgment in 2002, it failed to award to the appellate interests, which, by virtue of the law, it should have done, interest at the rate of 12%.
Just before you go on, could I please ask you to identify which aspects of the calculation are now in dispute? And for my part, I found Annex 2 to the respondent's case very helpful because it sets out in a comparative way the two sets of figures. And if one looks at Annex 2...
Have you got it yet, Mr. Tiluk-Darry?
Yes, my lords. Yes, my lords.
If one looks at Annex 2, the first issue between you, now that the question of the multiplier, the penal rate has been decided, is whether or not it's 291 months or 322 months. So that's one issue between you.
The first issue.
There doesn't appear to be any dispute between you about the figure of 68,640 rupees,
No.
which is the 3 months' wages in lieu of notice.
Correct. This is,
Isn't there another issue
Yeah.
in 41 and 51? The salary.
Yes, I beg your pardon. So just going back to the first block, the second point between you on the first block is the difference between the rupee figure of 41,374, which the respondent contends for, and the 51,435 that the appellant contends for. So those are the first 2 points.
yes, my lord.
Have I correctly understood that the next dispute between you is the question of interest?
Yes, my lord.
And the final dispute between you is the question of deductions, which is, first of all, tax, and secondly, the housing loan.
Exactly.
So those are the points between you. Have I correctly understood?
Yes, my lord.
Now, which of those points was actually in issue before the Court of Appeal, the Supreme Court of Mauritius, before the case came to the Privy Council?
My lord, all these issues were in dispute before the Supreme Court regarding continuous employment. The figure of continuous employment was in dispute as early as before the industrial court.
Yes.
And on this we have a correct pronunciation of the learned magistrate. That is, between December 1969 up to October 1996, almost 27 years minus 2 months. So that would be 27 multiplied by 12 minus 2 would be 322 months.
Yes.
But the Supreme Court computed it to be 291.
Yes.
That is, they have subtracted the time that the appellant went to study with the consent of the respondent.
Right.
And that was not correct for the purpose of computation for severance allowance.
Okay. Now,
Now,
in terms of the next dispute,
the next is
41,000 and the 51,000, that too was in dispute
Yes.
before the Court of Appeal, the Supreme Court.
that is, the Supreme Court failed to take into account that remuneration would include all entitlements, such as the privileges like interest rates, duty-free, housing loan, a lower rate of interest, sick leave and local leaves, because sick leaves could be cashed, and by virtue of the PRB report 1993, appellant was entitled to have a bank sick leave. And on this issue, we have a letter from respondent's attorney, which at a later
It was just to identify
Yes.
which points have been dealt with at this stage, rather than to
And
elaborate.
regarding
further.
interest, we have to go by the virtue of the law, Labour Act, which
Now,
provides.
was the question of interest rate dealt with by the Court
Yes,
of
my
Appeal?
lord. In the application for conditional leave,
No.
the
Where was it dealt with?
Where was it dealt with by the Supreme Court?
Supreme Court failed to award interest.
Mr. Tiluk Dari, the Supreme Court judgment we're looking at starts at 32. And my Lord's question is, when we read this judgment that goes on to 39, where do we see the Supreme Court dealing with interest?
My lords, I will have to cross-check during the break and give a definite negative answer. But for the time being, I can invite your lordship's attention to the affidavit of the respondent that is in the record. It would be at the smallest bundle, that is, as from page 1028. So it would be as from page electronic record 1036.
Are we talking about page 32 in the little bundle?
And it would be that would be correct, my lady. And
The top of that page.
on the top of that page, applicant's dismissal was unjustified and ought to have ordered severance allowance at punitive rate and with interest from the date of dismissal to the date of payment. That is by virtue of the labour law. Now, if we compute the rate of interest, it would be 12% of about 4.2 million, which would arrive at 1,983 rupees per day.
Did you want to complete your deductions?
Yes. Just before we go into that, could you just help me, please, with the final group of issues between you, which is the deductions? Were they dealt with by the Supreme Court?
The issue of it, I beg your pardon, my lord.
The tax deducted at source
Yes, my lord.
and the amount which is said to be due in respect of the housing loan,
Yes, my lord.
were they dealt with by the Supreme Court?
No, my lord, because at the time the appeal was heard by the Supreme Court, respondent's view was that nothing is owed. After the judgment of the Privy Council, my client started execution of the judgment, and then there were part payments. From the part payments, respondent deducted And I would submit that unlawfully deducted an amount for housing loan and an amount for interest, because no interest was due. And in any event, that was time barred for a compensation that was owed sometimes back in 1996, and same were being offered in 2007, and this was obviously time barred. And regarding the housing loan, what is interesting, I would pose here to say that at an earlier stage in 1996, respondent demanded immediate payment for the housing loan and the car loan after having summarily dismissed the appellant. Yes. Letters of my instructing attorney qualified it as threat in the index. Letter of threat was sent by the attorney of the respondent, and they started procedure to seize the car and the house of the appellant. Appellant obtained an injunction de justesse to prevent them from seizing his car, and for the car he had to pay, but for the house he obtained an injunction. Now, following that injunction, he lodged a statement of claim. The statement of claim, the matter was heard recently in 2013, where the court upheld the preliminary objection of the respondent, and the matter is now on appeal. It is still sub judice. And my client says he had paid a major part of the housing loan.
Now, let's just get this clear. Yes. What order what's the date of the order which is subject to appeal?
That is, regarding the issue of housing loan.
The appeal to which you have just referred.
Yes.
You said it's on appeal.
It's on appeal.
And we must understand
yes.
the date of the order currently appealed against.
That's fine. Is the
While that is
the
being
yes.
checked by you,
yes,
I want to say something, if I may, to Mr. Persem.
Yes, my lord.
Mr. Persem, the technology in Mauritius is so good that we could almost hear what the gentleman on your right was saying to you. And so we shouldn't be hearing that. I couldn't really decipher, not that I wanted to, what was being said, but we could almost hear it. And I think the two of you have got to be careful to speak in real whispers
I do apologize.
in order that...
The on my right is indeed my instructing solicitor in Mauritius, Mr. André Robert, who's been instructing me along with Mr. David Miles, my lord.
No doubt, but I think I just wanted to warn the two of you to keep your whispers so quiet that they can't possibly be amplified and brought to London. Have you now got the date
yes.
of the order against which there is a current appeal?
Yes, I have, my lord.
What is it?
The order is an interlocutory judgment at page 254 up to 259.
That's Judge Balance's.
Justice Balancy. We have not...
Before we lose the point about the housing benefit loan, it was being put in a slightly different way in the Supreme Court, wasn't it? It was being said that it was a complément de salaire, and therefore it should be paid to him or should be treated as part of his remuneration. And the Supreme Court did deal with that, didn't they? That has the same effect as to whether it can be reclaimed or not, I think.
My lady, that would be a different issue before the Supreme Court. Before the Supreme Court, the issue was the entitlement to a housing loan at a lower rate of interest than the current going market rate of interest. And the difference in the interest rates, it is our respectful submission that the difference in the interest rates would amount to an entitlement of the appellant and could be quantified and could form part of his remuneration. And it was not a mere liberality, what the Supreme Court has said. We took the issue in the affidavit. But regarding my Lord's question about the housing loan, that was an altogether different issue when respondent wanted to seize appellant's house at a premature stage when he had not yet lodged his claim for severance allowance. He obtained an injunction and he lodged a main case pursuant to the injunction. The appeal was dismissed by Justice Balancy on the 12th of June 2013, and the matter is awaited, that is listed for appeal to be heard on the 28th of March next year. And I must say that we have some difficulty because the appeal could not be heard earlier because the Court of Appeal is constituted by the Chief Justice or the Senior Preeminent Judge and 2 other judges. Now, being given that before Mr. Matadin, Mr. Sikuan was the Chief Justice, he was involved in many applications and appeal. He could not preside over the matter.
Very well.
Mr. Matadin also could not preside the matter. Mr. Balancy is next in line. So we'll have to await for Mr. Matadin and Mr. Balancy to go on holidays. But then next come in line is Mr. Konai. Mr. Konai also will have to take holidays for the Court of Civil Appeal to be constituted.
Thank you very much for explaining.
Yes. But save that.
For explaining an apparent 5-year delay.
Yes, but save that.
That's very clear.
Yes, but
now,
save that.
Can I just attempt to summarize in my own mind the net effect of Lord Kitchen's questions? So if you've got Mr. Persem's Annex 2 in front of you still, I put it to you as follows, and then you must knock me down and tell me I'm wrong. There are 5 outstanding issues between the parties in respect of the computation of the sums payable to you. The first one is 291 months against 322.
Yes, ma'am.
That was decided against you by the Supreme Court.
Yes, ma'am.
The second one is 41,000 rupees as against 51,000 rupees.
Yes, ma'am.
That was decided against you by the Supreme Court.
Yes, ma'am.
And your point is that both those decisions against you must be taken to have been set aside by the Privy Council. The third issue is interest. 11% according to the Sugar Board, and then 8% according to the Sugar Board. No, you say, 12%. That's an issue that's not yet been adjudicated. Number 4, less tax deducted at source. The Sugar Board say, deduct 816,000 rupees. You say, no. That issue has not been decided. Housing loan, the Sugar Board say, deduct 167,000 rupees. You say, no, quite wrong. Issue not decided. Now, have I more or less correctly summarized the effect of my Lord's questions and your answers?
Exactly.
Thank you very much.
Exactly.
Please proceed.
Yes, my
and we'll try not interrupt you so much,
Yes,
Mr. Tieluk-Derry.
My Lord, the Privy Council allowing judgment of the appellant in all circumstances. That is, the only issue is whether he should have been given a hearing. And obviously this is a substantial point in law. When allowing appeal would mean that appellant succeeded along all lines. That is, the computation as per appellant's plain, together with interest rate as per the Labour Act, starts running from the date of dismissal up to the date of payment. Now, what happened? This victory became almost a Pyrrhic victory, and with due deference to the courts in Mauritius, it became more sour than a defeat. My client wanted to execute that judgment. He sent 2 letters to the respondent. Respondent only reacted after 45 days. Respondent offered only a payment much less than what he claimed. And our calculation is to be found at, I'll come back to it at a later stage.
Can we help you? What calculation?
In the appellant's case,
Are we looking for your calculation of the amount owing?
yes.
Well, we have got that somewhere.
At
I
paragraph
wondered
18,
whether it was at 162 in the bundle.
Thank you, my lord.
Of course, that's only up to 2012. And so, on your case, there's 6 more years' interest. But at 2012,
Yes.
wasn't this what you said,
Yes. No,
per your accountant, was owing?
yes. And same is reproduced in the appellant's case at paragraph 18. And that would be
Yes.
pages 537 onwards. At page 545.
Internal page number?
545.
In your case?
It would be in the record, page 545.
I don't think I've got a 545.
Appellant's case.
We've got the appellant's case, your case of the 10th of October.
If we can have a look at paragraph 18.
Give us the paragraph.
Paragraph 18.
18, thank you.
It hasn't.
Yes.
Yes.
Now, the computation of the appellant. This computation was already done by appellant solicitor prior to the judgment of the board, when the appeal was restored sometime back in 2005. The appeal being restored, appellant wanted a settlement before the judgment, and it was computed by appellant solicitor. Letters have been sent to respondent then solicitor, Mr. Russell, and the interest rate has been computed to be 12% of 4.2 million, divided by 365 days, would amount to 1,983 rupees, which is almost £50, divided by 40, £5 per day.
Yes.
So this is the interest rate, and started running as from the date of dismissal, 1996. So as at the date of the decision of the Privy Council, there was almost 3,820 days, and the capital amounted to about 4.2, and the interest rate about 5.2. So when the first payment was made, about 2.9 million rupees by the respondent. Now, I must say that respondents have been taking different stands. First, before the judgment, that nothing is owed. After the judgment, they say that we have to compute it as per the Supreme Court, multiply by 6. They made a first payment on the 9th of May 2007. And they say that this is full and final. My client sent letters, sent notices to them. And they said they computed everything as per the law, international conventions, etc. But a few months later, they proposed an additional of 2.5, which they reduced to 2.4 for interest. Today, in their statement of case, they say they have paid everything. But then in 2013, after the first part payment in 2007 and 2009, my learned friend, Mr. Juniaville QC, said a very large part has been paid. We are saying, obviously, that a very large part has been unpaid. So we have the respondent who is unsure of prior to judgment. They were consistent, nothing is owed. After judgment, they are giving us different figures. Now, coming back to the execution of the judgment, my client has been like Sisyphus. He went before the judge in chambers for an application for attachment. Now, the application for attachment was set aside. The judge in chamber found that there is no exact figure, and the judgment is to be found.
Well, that's all ancient history, really, isn't it, Mr. Tiluk Dari? I mean, that's all ancient history, the attachment and the failure to attach. The central issue that you're going to come on to, I know, quite soon is how can we be talking about execution? How can you be seeking to execute on the movables of the board before the outstanding issues of quantum have been ruled upon?
Yes. My lords, we come from a former colony of the UK, which prior was a French colony, and by virtue of the Treaty of Capitulation, the civil code, it is a mixed system. We have the Code de Procédure Civile, and we also have legislations like the District and Intermediate Court rules, which the British dispatched by way of ordinance as early as 1888. And we have various modes of execution. There is no uniformity. My client wanted me to convey to your lordship that in Mauritius we would need a judgment to have some uniformity regarding judgments of the Privy Council. But we have Rule 20 of the Mauritius Appeal to Privy Council Order, which says that judgments of the Privy Council should be executed as other judgments of the courts. Now, having obtained judgment before the Industrial Court and having been unsuccessful before the Supreme Court, application for attachment on appeal before Justice Sikuen and Justice Kunai, when they identified the issue, you have a judgment. How about executing it? But yet they set aside the application, which in our contention would be a denial of justice, a violation of Section 29 of the DIC. Now, my client went to Supreme Court anew for a reassessment and the interpretation of the judgment of the Privy Council before Justice Matadin and Justice Kunai, now Chief Justice. And with due deference to the Chief Justice, Mr. Matadin, he is the only judge who says clearly that you got a Privy Council judgment. The Privy Council did not intend to remit it back to the Supreme Court. You go and execute it. The figures are there. It is for you to look for the figures.
Let's look at what he said. That's
Yes,
very helpful. Thank you. Is this the transcript that's in the new
Yes, my lord.
bundle?
As from page 1015 to 1000 and 1027.
I haven't got that pagination, but we can follow. Perhaps you can give us internal page numbers too.
Yes.
It's tab 2 in our new bundle.
Page, it would be in the new bundle at page 4, or in the electronic record at page 1020.
Thank you.
And the address, the issue raised by counsel, my friend Ramchand for the appellant then, the main issue is quantum, my lord. The main issue to be decided is quantum. The parties cannot agree on the quantum, and this we are coming under the court. Well, it is for you to decide. The judgment, insofar as we are concerned, the judgment is clear. We have read the judgment of the Privy Council. The judgment of the Privy Council is clear. You may not agree with Mr. Juniaville. This is another issue. But insofar as we are concerned, the judgment is clear. You should have other avenues. There is a judgment. You go and execute. You should decide. Counsel again, but the precise sum is not being agreed, my lord. The court goes on. The sums are there if you look for them. It is not for us to say so. We are not going to interpret the judgment of the Privy Council. And at page 7, that is 1023, again, well, in any event, it is not for the court to interpret the judgment. And it goes on. And the court at page 10, that would be page 1026. And he says that the court said, Mr. Matadin, Chief Justice, then SPJ, we have been confronted even
Which page are you on now?
Page 1026 or page 10 of the small bundle.
Can we go back to page 7 briefly, if it's convenient to you?
Yes, my lord. Yes,
You see at the bottom of page 7, the court is saying, in any event, this is not for this court to interpret the
Yes,
judgment.
yes.
It's for the parties, if they're not happy, they go to the appropriate forum,
Yes.
and this is not the appropriate forum here.
Yes.
I do understand what you were saying about the comments of the learned judge on page 4, but he does seem perhaps to have clarified his position a bit by saying, if there's any dispute, it's at least not for us in the Supreme Court to sort it all out.
Yes, now,
We shouldn't miss as well page 5 whilst we're looking at it, should we?
Yes.
He went on a little bit further about his understanding of the Privy Council judgment, that only one point was being argued. So the line seems to be, it's clear from the judgment of the Privy Council, only one point was being argued, but if you've got a difficulty, then we're not the right court to resolve it. And I think you were going to take us to what they said about what was the right court.
My lady, that is, when the appeal would be allowed on a substantial point, the Privy Council will not be interested to look at minor points. Therefore, we would say that if the Privy Council says the appeal is allowed in all circumstances without any saving or proviso clause, that part of the judgment of the Supreme Court is being retained, then the Privy Council has decided not to go by the Supreme Court judgment at all,
I understand
but to
that.
go by the plain.
I was actually asking a slightly different question, but whilst we just pursue that line,
Yes.
if what had happened had been that the industrial court had made an award on the statement of claim. I'm sorry if I haven't got the right terminology, but you understand, I think. And had said he is owed X. And then it went to the Supreme Court, and they said no. And then it went to the Privy Council, and they allowed the appeal against the Supreme Court. I can see that that might lead to the restoration of the industrial court's finding. But in this case, what the industrial court said was there is no money to be paid. And therefore, it then left a vacuum, if you like. And so that's why I think, as I understand your case, you're seeking to go back to precisely the sums claimed in the original claim. Yes, I've understood that. Thank you very much. What I was actually wondering was whether I'd interrupted you and you wanted to go on to point us to...
That is, the Supreme Court in Mauritius had a major difficulty because they cannot interpret a judgment of the Privy Council without any specific direction. And Justice Matadin, for him, this is a final judgment. Appellant should go and execute. It has other avenues. And pursuant to this, the appellant went before the industrial court. Now, prior to coming to the warrant to levy, at page 10, the court remarked of the small bundle, we had been confronted even with a direct or even with a specific direction in the case of Pandi, a former magistrate who had been dismissed. He applied for judicial review, leave was refused. He obtained leave before the Privy Council, but he wanted damages also. So this issue was referred back before the Supreme Court. And here, the court notes that there is no specific direction to remit the matter to the Supreme Court. So, in other words, this is a final judgment. The judgment is supposed to put an end to everything. And on this issue, the submission before Justice Duma by Counsel Ichi is very relevant, where he cited orders on pleadings to say that a judgment is supposed to put an end to everything. We cannot go on back to square one because this is a fundamental principle in democracy. The courts have given decisions, judgments, and the judgments are to be executed. Who are to execute? It is the executive. That is, my client went before the industrial court, the original court. I have obtained a judgment from the Supreme Court. Now, application for warrant to levy, this is a procedure provided under the laws. A warrant to levy is not obtained on mere asking. My client had to produce documents before the industrial court. My client came with a first précipé on the 31st of October 2012.
Page 154, I think you want us to look at.
Yes, my lord. The first précipé was dated 31st of October at page 153. But then he was asked what are the part payments that have been made. And he had to come with another précipé on the 22nd of November 2012 at page 155 of the record. And he had to state that a sum of 5.4 million was paid on two occasions, 2.9 on the 9th of May 2007.
Yes, we know about all that.
Now, and he had to produce a copy of the sealed order. Now, in view, and the figure was not computed again. That is, he obtained a warrant to levy at page 157 for the sum of 157 and 158.
Can you just help us on the warrant to levy on 157?
Yes, ma'am.
You had computed the interest
Yes.
that you said was owing.
Yes.
It's all rolled up in your revised precipice of the 22nd of November 2012. But when the Industrial Court comes to act on that and to give a warrant to levy against the goods of the board,
Yes.
it doesn't actually adopt your figure.
Yes, ma'am.
It adopts the sum you originally claimed, 4,209,000, and interests. But it didn't actually accept your sum for interests. It just said interests. Well, that wasn't very helpful because there was a dispute about interests.
Yes, madam.
Can you help us on that?
Yes, madam. That is, when my client went before the Industrial Court and they said that interest is something that is ongoing. That is 1,983. And it is ongoing up to the date of payment. That is, we don't know whether he will be paid or whether he has to seize, restrain the articles and have it sold through the usher. Now, the computation they did, they added costs and application for levy.
Yes.
About 9,000, and they still added plus interest. So this is their computation. And it is our humble submission that interest is, as per the Labour Act, 12% of this sum as from the date of dismissal and as per the calculation. So
Well, we know that you were saying that interest should be at the rate you were claiming. But there'd been a lot of correspondence in which the board had said, no, 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 you're claiming excessive interest.
Yes.
And so there was an issue about that.
that is obvious.
How, because this is central really to the whole appeal, how did you think that you could ask the usher of the court to execute in respect of interest about which there was an issue between you and the board?
My lord, we would be in the shoes of creditors, just like banks, who want to recover demand for payment. And even if the sum is not precise, and I put in for that purpose a case of it's record at page 77 to 73, Bank of Baroda versus Panesar. Where it was held in the first page, where creditor was entitled by the terms of his security to demand repayment of...
I beg your pardon, where are you?
On record at page 77. No, 717. I'm sorry, my lords.
So the bundle of authorities.
Yes.
That's not the record as such, is it, Mr.
Yes,
Tieluk-Darry? But thank you. It's tab 15. Yes?
Sure.
Yes?
That is the second paragraph, held giving judgment for the bank, where a creditor was entitled by the terms of his security to demand repayment of all monies thereby secured. There was no need for him to specify the precise amount of the debt in making a demand for the monies due thereunder. Accordingly, a valid demand for monies owing to the bank from companies had been made. So this is the position in Mauritius, and it has been adopted. In the bundle of authorities, I have listed case on tab 21, 24, 13, 29, and 34, along the same line, where the same principle has been adopted. Whenever there is a demand for payment, one must pay, notwithstanding that the precise sums are not due. But there, they were not judgment creditors.
Well,
they
quite.
had a charge.
They were.
So here, my client has a judgment of the Privy Council, and here is asking balance due on judgment debt, right? And I have also listed cases at tab 16, 32, 28, 38. I won't elaborate on those issues, save to say that the courts in England have been protecting prospective creditors from being defrauded by debtors, where debtors tried to squander property, to hide property, to conceal property. And if the courts can protect prospective creditor, courts must be able to protect judgment creditor as well.
Yes, now what's your next point, please, Mr. Tiluk-Derry?
Why not? I have come back to the issue of execution of judgment, and I have cited doctrine Dalloz procédure civile. It's tab 41.
Now, what textbook are we looking at here?
That is, my lords, my apologies. The doctrine of Dalloz is in French.
Oh, Dalloz. Very well.
And paragraph.
So Dalloz is a French text, but it is part of the law of Mauritius.
Part of the law.
Which bit do you want us to read?
That is, force exécutoire du jugement.
Yes.
What is of interest to us is paragraph 504, 505, and 506. The three paragraphs are important as they say that le jugement donne à celui qui l'a obtenu le droit de poursuivre par la force l'exécution de la décision rendue à son profit. La partie gagnante dispose à cet effet des voies d'exécution. And it goes on to say that prior to that there must be notification. In the next paragraph it says that the state must enable a person to execute judgment, and the Constitutional Court in France had to say that it is the corollary of separation of powers. That is, courts deliver judgment, executive has to enforce the judgment, has to help the appellate, which the ushers have done in Mauritius. They were prevented from doing so on 2 occasions. And it goes on at paragraph 506 to cite the jurisprudence of the Court of Strasbourg.
I mean, all that,
Yes.
speaking for myself, Mr. Tiluk-Derry, is sound law, elementary law, and very important.
Yes.
If there had been a decision that your computation of interest was correct, there would be no problem about execution, and you probably would not have been enjoined, as you have been, from proceeding to it. The central issue, and we come back to this time and time again, is there is an issue about this. Has that not got to be determined first?
For the laypersons, it may be a question, an issue of semantics, but for Lord Neuberger, allowing the appeal in all circumstances,
Yes,
for him would say that appellant has won along all lines.
Yes, I
we
see.
take his figures
Well,
and
that's
we
very
compute interest as from the date of his dismissal. That is in 1996 as to date.
That is helpful because it means we must really focus on what we understand to be the effect
Yes.
of the previous board's decision.
Because obviously when the previous board would hear that appellant had to battle 11 years, between 1996 up to 2000 without any salary, without any pension. And he had to pursue his claims, his appeals up to Privy Council. His appeal has to be restored. This is an ordeal for an ordinary man. Now coming back on 2 occasions, that's a...
Mr. Tiluk Dari, I'm going, forgive me, to interrupt you for a moment, because all of a sudden we lost Mr. Persem and Mr. Nursimulu, and we must get them back before you say another word. Mr. Persem, you're back now. Can you explain what happened and why we lost you for about 3/4 of a minute?
Yeah, my lord, I surely cannot explain, but I could hear you very clearly, my lord. But you're right in terms of we seem to have lost the image on the screen for a short while. I unfortunately cannot explain the reason why we lost the image for a very short while.
The important point is whether did you continue to hear what Mr. Tiluk Dari was saying?
Indeed, my lord, we heard everything that was said.
Good. Thank you very much.
Thank you.
Mr. Tiluk Dari, I'm sorry to have interrupted you, but we had to have that sorted out.
Yes, the main issue, that is whether an injunction would lie. It is our respectful submission that there is no injunction against a judgment creditor who wants to enforce a judgment and to claim the balance due. We have listed issues that they have failed to, that is the balance of convenience, right? Whether the balance of convenience tilted in favor of the appellant. A person who had been dismissed without hearing, without compensation, had to struggle 11 years to obtain judgment. Now another 11 years back again to square one. Now, 11 years, he has been dismissed at the age of 51. An age where it is impossible in 1996 to obtain employment in the government sector. In the private sector, at that time, they would recruit youngsters because they have to pay pension. They would prefer to recruit a person at the age of 30 instead of 51. Now, with his qualifications, with all the time, that is, he devoted the best part of his life, 27 years to an institution. He even attained the top managerial position of Deputy General Manager, being dismissed and had to, with a begging bowl before the courts in Mauritius. Fortunately,
Mr. Tiluk Dari,
yes.
You're obviously a very able advocate in seeking to attract the sympathy of any court or board that you address. But I'm not sure that these points about substantial merit and injustice go to the heart of this appeal.
Now, my lords, I come back to the main issue. That is, we leave aside the powerful emotional argument and we come to the legal argument. That is, the judge in chambers had jurisdiction in equity. Injunction is a discretionary remedy. He had, on the one hand, SIFP, a powerful insurance institution which is a parastatal embodied under the law. Now, we have a judgment creditor who is claiming at the material time 4 million or up to 10 million with interests. As at 23rd of November 2013, that is about 6.9 million rupees. We have, on the other hand, SIFP, who reckons a reserve of about 5 billion rupees. Now, claiming, that is, removing a glass of water from the swimming pool. 5 billion rupees. Now, claiming that is, removing a glass of water from the swimming pool. 5 billion rupees. Now, claiming that is, removing a glass of water from the swimming pool. 5 billion rupees. Now, claiming that is, removing a glass of water from the swimming pool. 5 billion rupees. Now, claiming that is, removing a glass of water from the swimming pool. 5 billion rupees. Now, claiming that is, removing a glass of water from the swimming pool. 5 billion rupees. Now, claiming that is, removing a glass of water from the swimming pool. 5 billion rupees. Now, claiming that is, removing a glass of water from the swimming pool. 5 billion rupees. Now, claiming that is, removing a glass of water from the swimming pool. 5 billion rupees. Now, claiming that is, removing a glass of water from the swimming pool. 5 billion rupees. Now, claiming that is, removing a glass of water from the whether the balance of convenience would have affected so much, substantially, the respondent by paying this sum. The respondent could again say that, could have paid, complied, and then say, no, I have paid more than what I had to pay, I'm going back to court. But no, we say that an injunction would not lie. Judgment creditor?
I beg your pardon, Mr. Telic-Darry, I didn't mean to interrupt you, but may I ask you this? The main case, as I understand it, has been described, is due to be heard on the 7th of March next year. May I ask, what issues are going to be before the court on that occasion?
My Lord, if I can answer the question, that is, the respondent obtained an injunction. That is, appellant trying to seize respondent's property. And it is damages that respondent has suffered as a result of attempt to seize respondent's property.
Well, that will be so.
That would be solely for that issue. That is,
but that will only happen if it is found that the seizure was not appropriate.
Yes, yes.
So how is the court going to decide which of you is right about what remains owing, if anything? Is the court going to look at the question of quantum and how it should be assessed and calculated or not?
No. These issues, they are not an issue. That is the computation of the appellant. These are not an issue. It's a collateral matter where they are saying they suffered prejudice. The ushers went on their premises on 2 occasions and they are claiming damages to the tune of 10 million.
But I beg your pardon, your response to that will presumably be that you were entitled to execute. And they're going to say, no, you weren't, because we've paid you all that was due and owing.
Yes.
So is the court not going to have to look at quantum in order to resolve that fundamental difference between you?
May not. That is the issue, is whether they suffered prejudice by the fact that the ushers went on the premises. Because eventually there was no seizure. And what is the prejudice? And the court in Mauritius, it's true, it is scheduled in March 2019. But then, before trial is disposed of, the appeal, we are back to another decade of litigation before the courts in Mauritius regarding this collateral issue. So that does not help the appellant.
Could I ask for clarification about this case that is going to be heard on the 7th of March? Could you go to 333 in the bundle, please? In the record. It's the first page of the judgment of the Supreme Court under present appeal.
Yes, Madam.
And in the second paragraph, the learned judges say, this order was to remain in force until determination of the main case, SCR 107614, which the appellant had in the meantime lodged against the respondent and which is still pending. Now, the appellant was your client. Did your client lodge this case against the board, or have the judges gone wrong there?
Obviously, they have gone wrong, Madam.
They've gone wrong?
They have gone wrong.
Very well. I wondered about that. Thank you. Yes?
So the pending litigation, that would be...
I beg your pardon, just before you go on. So the main case which reference is there made is not the case which is going to be heard in March next year, is that right?
That is the case where...
It is.
Appellant tried to execute warrant to levy, and ushers went on the premises twice, and they say they suffered prejudice to the... It says it suffered prejudice to the tune of 10 million rupees. So this is
There
the
are
issue.
2 cases to be heard in March.
Yes, yes,
There's one on the 7th of March.
yes.
That's the Sugar Board's
Yes,
main case.
Yes. And
Then
the
on the later in March, on the 28th, you're appealing against the order of Judge Balancy.
Yes, regarding the housing.
Thank you
yes,
very much
bylaw.
indeed.
My lords, the practical effect is that judgments should be executed. Otherwise, we are back to square one. In Mauritius, a respondent who has been defeated before the board will be entitled to apply for an injunction and then lodge a main case on account that the judgment is not clear, so that proceedings would be, litigation would be ongoing, whereas there should be finality, my lords. That is, each litigant who comes before the board, if he loses, he says, no, I have not lost, I'm going back to apply for an injunction, I'm going to put a main case, and it will keep on rolling.
Thank you. Now, where are we going from here?
Yes. My lords, it is my respectful submission that though an injunction is supposed to be discretionary and a temporary remedy, an injunction does not lie here where we have a judgment creditor claiming balance due. And we have, and respondent took objection that we have mentioned the reserves of 5 billion rupees. But this obviously, it falls under disclosure. That is, one who comes to equity must disclose. There is an attempt to seize property. What is the reserves? If it is much below their reserve or it's beyond their reserve, this is disclosure. One who comes to equity must come with clean hands. We have listed all the issues, and I have elaborated these issues in my statement of case. I do not propose to say more. Regarding the Supreme Court upholding the decision of the judge in chambers granting the injunction, I would say that they again went completely wrong. And by the end, they said we have not canvassed some issues regarding execution. And same is to be found at pages 337. That is, we have listed to the court in chambers and before the Supreme Court that there is section Rule 20 of the Mauritius Appeals to Privy Council Order, section 16 of the Courts Act, section 29 of the Courts Act, and section 9 of the Industrial Courts Act, which means that a judgment should be executed. And in addition to it, there is no need to canvass further when the law is clear, whether one should come with authorities. But today, I must say that I have authorities, European Court of Human Rights, and I have put it in the bundle. That is at tabs 19, 25, 26, 30. And they all hammers one issue. That is, if we go to page 851,
Yes.
yes,
The Hornsby case.
yes,
Very well.
and the relevant paragraph is at Hornsby case 26. At paragraph 40.
Very well. Yes.
Right. The court reiterates that according to its established case law, Article 6, which is similar to Section 10, subsection 8, which I have reproduced in my statement of case, that is, the right of a person to a fair hearing. This right would imply the execution of judgment, if I may paraphrase. And it goes on to say that it would be concerned, it would be incompatible with the rule of law, where contracting states who undertook to ratify the convention, and it goes on to say execution of a judgment given by any court must therefore be regarded as an integral part of the trial for the purposes of Article 6. In the present case, it would be Article 10, subsection 8 of the Mauritian Constitution, and coupled with Article 3 of the Constitution, that is, right to protection of the law.
None of that is in dispute.
Yes.
Execution of judgment is crucial to the whole democratic system. We can entirely agree with you about that. Now, I get the impression that you're coming to the end of your submissions. I may be wrong,
yes,
but would you like to wind up, Mr. Tiluk Dari?
My lords, that all the issues I have listed are contained in my statement of case, and we would say that on the pretense that they say the figures are not clear, they are flouting the law and denying justice to a litigant, the more so that Supreme Court has powers to administer the laws under Section 15 of the Courts Act, coupled with Section 16 that it is a court of equity. And the Supreme Court also has supervisory powers to administer justice under Section 82, subsection 1 of the Constitution. I have not produced, but I undertake to provide same in the course of the day. The Supreme Court shall have jurisdiction to supervise any civil or criminal proceedings before any subordinate court and make such orders, issue such writs, give such directions as it may consider appropriate for the purpose of ensuring that justice is duly administered by any such court. And Section 15 of the Courts Act is along the same line. It is my respectful submission that this trial, that is the first 11 years and the second 11 years in trying to execute a judgment, constitute an ordeal, and it is indeed an epic. I have put in the case of Elizabeth Campbell, where she was told, Canadian case in 1929, where for the first time a lady litigant was allowed to appear before the board. And she was told that she would not obtain justice unless she goes on the other side of the water. My lords, unless I can be of further assistance, this is my submission.
Any questions? Any further questions? Mr. Tiluk Dari, thank you very much indeed.
Much obliged.
Now, Mr. Godari, are you going to follow? No, nothing. Thank you very much indeed. Well, we're going to rise now, but only for a short time, possibly only for 2, 3, 4 minutes.
Who will rise?
Mr. Persad.
Yes, my
We'd
lord.
like you to address us in opposition to this appeal. And we have found, as you will have heard, your Annex 2 extremely helpful. And we would like you in particular to address us on the issues that Annex 2 throws up, of which we counted 5: the number of months, the rupee salary to be taken into account,
Correct.
interest, tax, and housing loan. And we would like your submissions on whether all those issues have been resolved in your favour, or whether some of them have, or whether none of them have. And to the extent that there are outstanding issues, we would like your particular help on how they should now be resolved. So, in the light of that specific invitation, Mr. Persem, please make your submissions.
Yes, my Lord, thank you. My Lord, if we may go to indeed Annex 2, with your Lordship's permission, I would wish perhaps to deal with the issue of how the monthly remuneration ought to have been counted. In the contention of the respondent, the remuneration ought to have been 41,374, whereas in the appellant's contention, it should have been 51,435 rupees 88 cents. In this respect, perhaps it might be useful to take your Lordship to the judgment of the Supreme Court of Mauritius. I would like to perhaps to take your Lordship to page 35 of the record, my Lord. Your Lordship will see at page 35, or perhaps I should say 34 first. Your Lordship will see that the Lordship before the Supreme Court dealt with ground 6, which would have it whether the magistrate was right or wrong to hold that the benefit of the car loan, the housing loan, at reduced interest rate, and the purchase of a duty-free car every 7 years could not be considered as complément de salaire. Now, perhaps before I deal with the judgment of the Supreme Court, it might be useful to take your Lordship to page 45, because your Lordship will see at page 45 of the record, in the judgment of the learned magistrate, your Lordship will see fourth paragraph at page 45. The learned magistrate dealing with this issue of complément de salaire held that after going through the cases of Stella Insurance and Ramfol and CWA Subra, it is my considered view that the above items cannot be considered as complément de salaire since it has no fixité and cannot be considered as forming part of the plaintiff's emolument. Your Lordship will bear in mind that the appellant, when going to the Supreme Court of Mauritius, took specific issue with this finding, and your Lordship will see at page 35 of the judgment of the Supreme Court, second paragraph, it is settled law that a fringe benefit which is quantifiable in terms of money and actually paid to the worker is remuneration for the purposes of calculating severance allowance. Your Lordship will see paragraph 1, paragraph 2. At the end of paragraph 2, the Lordship dealing with this issue of complément de salaire, their Lordship said, again, one can hardly speak of complément de salaire where the benefits are far from being fixed. There was evidence that the appellant had already benefited from housing loan and a car loan and duty-free facility. And ultimately, the Supreme Court, in my humble submission, my Lord, reached the conclusion that they were not complément de salaire. Now, from there, I would like to take your Lordship to the concluding part of the judgment of the Supreme Court at page 38, where your Lordship will see that having dealt with this issue, whether these items could be considered as complément de salaire, at page 38, their Lordship said, with regard to the computation of the amount payable to the appellant, we must now take certain factors into consideration. Firstly, the appellant's period of continuous employment should be reckoned as being 291 months, after deduction of a period of 31 months during which he was on leave. And secondly, their Lordship at paragraph 3 dealt with the issue of what would be the correct monthly remuneration for the purposes of computing the severance allowance. So there were two items in my humble submission which were clearly dealt with by the Supreme Court. In other words, if we go back to the Annex 2, there is the item in relation with the month of service. Their Lordship before the Supreme Court reached the conclusion that it was 291 and not 322. And secondly, their Lordship before the Supreme Court clearly made a finding with respect to what the remuneration was, in other words, 41,374. Now, as your Lordship rightly pointed out, when the matter was argued before the Privy Council, rightly or wrongly, the only issue which was raised before their Lordship, before the Privy Council, was whether the termination of employment was justified or not justified. It would seem that the appellant then before the Privy Council had abandoned any issue with respect to the number of years of service, not to say month of service, and secondly, the issue of what was the monthly remuneration. Perhaps to correct one misunderstanding with respect to this issue of car loan, duty-free car. As my learned friend Tilak Dari perhaps said earlier, to the extent that their Lordship before the Supreme Court of Mauritius dealt with these items, what they were trying to determine was whether these items ought to be included in the computation of remuneration, and there was no finding with respect to whether the loan was outstanding or not. So that the
yes,
only
Mr. Passem,
issue...
can I interrupt you there?
My Lord, yes.
They dealt with the car loan. They decided it was libéralité and not
Indeed,
complément de salaire.
Indeed.
That informed their decision about the amount of the remuneration. But
Indeed.
Does their decision bite upon what we have called issue 5 in Annex 6, namely less amount due to the respondent, housing loan? You've said deduct 167,000 rupees. No, says Mr. Tilak Dari. My question to you is, are you saying that the Supreme Court must be taken to have decided that point?
No, my Lord. I certainly agree that this was an issue which was not decided before the Supreme Court. As your Lordship have rightly noted, the issue of loan is already before the subject matter of litigation before the Supreme Court, and this is a matter in relation with which the appellant has initiated proceedings before the Supreme Court of Mauritius. We know there was a judgment of Mr. Balanci, which is now on appeal. But to answer your Lordship question, it is perfectly right to say that the Supreme Court did not deal with the issue whether the loan was outstanding or what was the amount of the loan which was outstanding.
Thank you.
Now,
so does it follow that issues of interest, issues of deduction of tax, issues of housing loan deduction have not yet been decided?
I certainly concede that these are issues which have not been decided, but with respect to the issue of tax and interest, if I may, with your Lordship's permission, My learned friend contention is that the rate of interest which is payable is 12%. It would appear that my learned friend is relying on section 36, subsection 9 of the Labour Act, which was then in force at the time the appellate was dismissed. Now, if I may take your lordship to the that relevant provision, I understand it is at tab 7 of the bundle of authorities, page 622, my lord.
Well, Mr. Persam, if you think it's going to help us to look into the rival merits of the issue as to the percentage of interest, then for the time being at least, we will follow your submissions. But you may not be surprised to hear that, speaking for myself, I wonder whether we should be delving too far into the rival merits of the undecided issues.
If I may, my lord, perhaps if your lordship will allow me.
Of course.
Can I just perhaps take your lordship to section 36(9)? Your lordship will see that it's the section gives the industrial court a discretion whereby the industrial court may, where it thinks fit, and whether or not
what subsection are you reading?
Subsection 9, my lord.
Subsection 9.
Page 633.
Yes, thank you. Yep.
Your lordship will see that the court, which is the industrial court, the court may, where it thinks fit, and whether or not a claim to that effect has been made, order an employer to pay interest at a rate not exceeding 12% from the date of determination of the agreement to the date of payment. My submission is that this is a discretion which is conferred on the industrial court. At no point in time in this present case did either the industrial court or the Supreme Court, nor was there a request made to the Privy Council that, to the extent that the Privy Council reached the conclusion that the dismissal was unfair, that there ought to be an order in terms of section 36(9), so that this exceptional rate of 12%, in my humble submission, never became payable because there was no order in that respect. Now, the reason why the SIFB applied 11 and 8% is the legal rate which is fixed by law. That in normal circumstances, to the extent that judgment has been delivered in favour of a party, that party is entitled to interest at the legal rate. Of course, as I said, instead of the legal rate, the industrial court has this exceptional power to impose the exceptional rate of interest of 12. So in the present case, the submission of the SIFB, the respondent, is that at no point in time has any court of law decided that there ought to be interest at the rate of 12%. Hence the reason why ultimately the SIFB, when it paid the different amount it has paid, it has decided to apply the rate of interest of 11%, which was the rate which was enforced as from the date of the 4th of October to February 2004. After 2004, your lordship will note that the rate of interest was amended by law, and it was 8% which was payable. Hence the reason why it is the contention of the SIFB, the respondent, that the rate, the exceptional rate of interest of 12% is not payable, my lord.
Now, Mr. Persem, is any court in Mauritius at the moment being asked to determine the issue between the two sides about the rate of interest?
No, my lord. This is a matter which is closed because this is a matter which could only have been decided by the industrial court, it would have been open to the appellant when going to the Supreme Court to get the Supreme Court to rule on this section, or it would have been open to the appellant to ask the Privy Council, to the extent that the Privy Council finds that the dismissal was unfair, to make an order in terms of section 36(9). But to answer your question, my lord, there is no court which has been asked, which is being asked to determine this issue of whether the rate of interest should be 12, 11 or 8.
Then
So
the next question.
Can I just
after
finish
you,
that one up? So you're saying it's too late now?
In
to
my
ask
humble
for that.
submission, it is too late.
Thank
It is indeed too late.
Why is it too late?
My lord, this is a matter which ought to have been taken up, as I said, either before the Supreme Court. I can perfectly understand why the Industrial Court did not rule upon the matter, because the Industrial Court reached the conclusion that the dismissal was fair. The appellant appealed before the Supreme Court. It was open to the appellant to ask the Supreme Court to invoke section 36(9). Just as I said, it was open to the appellant to ask the Privy Council. There is this discretion in virtue of section 36(9), and this the appellant failed to do. And it is in my humble submission too late to go back to the court and ask the court to rule upon this issue at this juncture.
Well, that might be itself a matter in issue, Mr. Persem. Were Mr. Tiluk Dari to now ask the Industrial Court to decide the interest point, you would say it's too late. He would say it isn't too late. He would say that the Privy Council would never have touched an issue like that. You might lose.
I must confess, we have not had any situation, my lord, where subsequent to the disposal of proceedings, parties have gone back to the Industrial Court to ask the Industrial Court to determine this specific issue. But I take your lordship's point that it's a moot point as to whether it would be appropriate now at this juncture for parties to go back before the Industrial Court, for the Industrial Court to determine whether the interest rate should be 12 or the legal rate which I have indicated earlier.
And what do you say about the two deduction issues? Tax, housing loan. They've not been decided. Do you say it's too late for Mr. Tiluk Dari to ask the Industrial Court to rule upon them?
No, I think it would appear, my submission is that insofar as tax is concerned, again, that is an issue which is determined by the Income Tax Act. The Act would have it, if I can take your lordship to the relevant section. Now, I am informed by our junior that unfortunately the relevant schedule is not before your lordship. But my lord, the position in law is as follows: the person who is awarded severance allowance would normally get an exemption at the relevant time. It would have been 1 million rupees. Any amount which exceeds 1 million rupees is subject to taxation. So the manner in which the SIV proceeded was they allowed the appellate an exemption of 1 million rupees, which was the allowable exemption at the relevant time. And any amount which was over and above 1 million was subject to tax, because the law imposed on the SIFB the obligation to withhold tax. Hence the reason why the SIFB, when it decided to effect payment, withheld tax as it was required to do so in virtue of the Income Tax Act, my lord. Withholding provision.
Now, excuse me, may I just interject there? Who is going to decide the merits of the dispute between you in relation to tax?
My lord, in the event, of course, there is a dispute with respect to the quantum or the liability to tax, it would be open to the appellant, of course, to seize the relevant tribunal, which is in Mauritius the Assessment Review Committee, to the extent that the appellant reaches the conclusion that either the tax has been wrongly computed or that the tax is not due. So to answer your question, Milon, as I said, the Income Tax Act imposes that obligation on the SIFB to withhold and to remit the tax to the Mauritius Revenue Authority. Ultimately, if there is a dispute, it is open to the appellant because he would be deemed to have paid that tax. The appellant would be entitled to seize the relevant tribunal, as I said, if he believed that the tax was not payable or if he disputes the quantum of the tax.
The relevant tribunal being which tribunal, Mr. Persem?
It's the Assessment Review Committee, my lord.
Assessment Review Committee.
Indeed.
Thank you.
The procedure would have it that the appellant would, of course, write to the tax authorities, which is the Mauritius Revenue Authority in this case, disputing the liability to tax and perhaps the quantum, to the extent that there is a decision on the Mauritius Revenue Authority whereby it maintains its position that tax is payable and there is the decision as regard the quantum.
Yes.
Then, of course, the appellant would be it would be open to the appellant to seize the relevant tribunal to dispute the claim of the MRA.
So that would not be a matter for the industrial court. That
would not be so. That would not be so, my lord.
Then, thirdly, the housing loan.
The housing loan.
If it is necessary for there to be a determination of the issue about the deduction that you have made, how is that determination effected?
My understanding was that the nature of the loan which was extended to the appellant entitled the SIFB to indeed set off any amount outstanding against payment which was due to the appellant. Now, perhaps it would be interesting to take your lordship to page 65 of the record. Your lordship will see this is a claim which is entered by the appellant against the SIFB, whereby ultimately the prayers sought for by the appellant is an order in the nature of perpetual injunction restraining the SIFB from seizing or causing to be seized its immovable property, and so on and so forth. There's a claim for damages, etc., etc. But the relevant paragraph which I would like to draw to the attention of your lordship is paragraph 9 of this statement of claim, where your lordship will see it is stated by the appellant himself. On the other hand, as at 3rd of October 1996, plaintiff number 1 himself admit in his own statement of claim that he owed the amount which are set out at paragraph 9. Firstly, there was the housing loan of 67,463.18 cents. That is an admission which is made by the appellant, and it is in that respect that ultimately the SIFB decided to proceed with the deduction of that amount.
No, Mr. Persem, you didn't deduct 67,000 rupees. You deducted 167,000 rupees.
My lord, I am instructed to inform your lordship that that was the amount which was then outstanding. Subsequently, due to interest and so on, this is how the balance increased to 167,552. But your lordship is right. This is a matter which was not determined by the Supreme Court, which is the subject matter of litigation before the Mauritius court, and as my learned friend has indicated to your lordship, there is this claim. There was the decision of Mr. Balancy, and ultimately the matter is due for hearing before the appeal court.
And that appeal court will decide the question of whether or not there is an outstanding housing loan and what its amount is. Is that right?
Ultimately, the court will be called upon indeed to decide what is the amount which is due and whether the SIFB is entitled or not to seek execution of whatever charges it was entitled to.
And that is the appeal from Judge Balancy?
Indeed. Now, your lordship will bear in mind that the statement of claim which was entered by the appellant was set aside by Mr. Balancy on a preliminary issue. Ultimately, the Supreme Court will have to decide whether Mr. Balancy was right or wrong, but to the extent that the appellant fails in his appeal, the SIFB would be entitled to proceed with execution of the security which the SIFB is entitled to.
Well, that's been very helpful so far, Mr. Persem. You've made submissions about the outstanding issues and how in each case they might be resolved. So where do you want to take your submissions from here onwards?
My Lord, with respect to the 4 issues which have been raised by my learned friend, I have addressed those issues in my statement of case, if I may say. Those 4 issues have been exhaustively dealt with. At the risk, I don't know whether your lordship would like me to repeat, but I believe one of the first issues which was raised was whether an injunction lies against execution of a judgment. I think your lordship has rightly observed the question of execution cannot arise to the extent that there are still outstanding disputes with respect to the amounts which are being claimed. So that my humble submission is that the learned judge in chambers, when determining whether injunction lies or not, was clearly right in pointing out that there was indeed outstanding issues, so that the learned judge in chambers was right in reaching the conclusion that there was indeed a serious issue with respect to the application which was made by the SIFB, i.e., was there a dispute in relation with the amount which the appellant was trying to seek seizure or forfeiture? So that my humble submission is that the learned judge was right to reach the conclusion, if I may say, that there was indeed a serious issue. With respect to the issue of whether the respondent came to court with clean hands, my submission, as we have indicated, firstly, it was open to the appellant to raise this issue at the very outset after the issue of the interim order, on the basis that if the appellant felt that the judge in chambers had been misled. But your lordship will take note that at the initial stage, no objection was taken by the appellant. That is an issue which was only raised for the first time, if I may say, before the judge at a fairly late stage. But as indicated in our statement of claim, all the evidence which the appellant says were not placed before the judge in chambers, these facts were brought before the judge in chambers, and he reached the conclusion that they were irrelevant. And as indicated by the Supreme Court, I certainly agree with the ruling of the Supreme Court that those matters were clearly irrelevant. Now, the issue of whether it was equitable to grant the injunction. The learned judge in Chambers took into account the position or the functions which were being discharged by the SIFB. As against that, the learned judge in Chambers also considered the fact that the quantum which was being claimed by the appellant was still in dispute, and he reached the conclusion that the balance of convenience clearly lied in favour of the SIFB, and in my humble submission, the learned judge in Chambers can be faulted in that respect. Lastly, my Lord, with respect to inordinate delay, my short submission will be that one has to bear in mind that the proceedings were disposed of in July 2013, if I'm not mistaken, and the judgment of the judge in Chambers came out on the 5th of February of the following year, 6 months from the date the matter was heard. It is my humble submission that it cannot be said on the basis of the issues which were dealt with by the judge in Chambers, it cannot be said that the judge in Chambers took so much time as to be not to be able to deal with issues which had been raised before him, or issues which were pertinent in relation to the application. Lord, these are the 4 issues which the appellant have raised. We have dealt with those issues in our statement of case, and I wanted to say a few words in respect to each of those issues.
Well, we've read your statement of case. Can you help on one thing? This morning, you will have read with us the transcript of the hearing before Judge Matadine, the senior presiding judge, and Judge Cornier on the 3rd October 2012. And you'll remember the court, I don't know which of the judges it was, saying, it's in the supplementary bundle at page 13, talking about the Privy Council judgment. And they're saying, these, to Mr. Ramchurn, who was representing the appellant, these sums are there if you look for them. And so Mr. Tilukdari says, here was the Mauritian court saying, you've only got to look at the Privy Council decision in order to see what's due and owing. What do you say about that, Mr. Persem?
My Lord, my own reading of the transcript would be that when their lordship referred to the judgment, what they had in mind would have been, firstly, the judgment of the Supreme Court, whereby the Supreme Court clearly determined the remuneration. The Supreme Court clearly determined the length of service. These were the matters which, in my humble submission, Mr. Matadine and Mr. Kunai had in mind when they said when they indicated in the transcript that these were matters which were there, which were clearly set out in the judgment. Of course, they also referred to the judgment of the Privy Council because they were alive of the fact that the Privy Council only reversed the finding of the Supreme Court with respect to the issue of liability, to the extent that on issues of quantum there had been no pronouncement of the Privy Council. In the views of Mr. Matadine and Mr. Kunai, these were issues which were settled, and it was in that respect that, in my humble view, they said that the issue was clear. But of course, they could not have said that in relation with the issue of pension or perhaps the issue of tax and interest.
No. Right. Well, have you got any questions for Mr. Persem? Have you got any questions?
Thank you.
Mr. Persem, was there anything else that you wanted to say?
I think I have said, I have tried to respond to the issues which your lordship wanted to have some clarification. I have nothing more to add. I think that's about all. Perhaps my learned junior may wish to say what they wish.
I want to ask Mr. Nosimulu now whether he wishes to follow.
Thank you, my lord. I have nothing to add to my learned senior submissions.
Well, thank you both very much indeed. Now, Mr. Tilukdari, I know it's almost 1 o'clock our time, 5 o'clock Mauritian time, but unless you're going to be a substantial amount of time in reply, I wonder whether it would be convenient to make your submissions now.
Yes, fine.
Thank you.
I shall be very brief. My Lord, coming back to the last question that was put to my friend, Persa, about the observation of Justice Matadi.
Yes.
That is, we have the remarks of the Chief Justice, the figures are there. They are clear, you go and execute the judgment. This is a direction, and we cannot say that, we cannot submit otherwise. Now, regarding the issue of interest, my friend spoke of the schedule of the income tax. I'm submitting the income tax itself, section 114. That is, the tax authorities cannot claim tax for issues that is time-bound. 3 years prior, they can't go back time machine and claim. SIFP cannot withhold tax. They can give the severance allowance. If tax authorities want to reassess Mr. Bissonauth, it would be up to them. And the Assessment Review Committee starts, that is, procedures only start rolling when there is an assessment for tax. The appellant goes there to dispute the amount of tax that have been withheld. Sure. By not the SIFP, but by the Mauritius Revenue Authority. So this is a non-issue. The issue of interest was raised in the plaint dated January 1997. It was again raised in the application for conditional leave. And we have put in Labour Act, section 36, subsection 9, which says that interest is payable up to 12%. We included 2 case law to suggest the cursus before the industrial court, the case of Bundu on the issue, and also, which is at tab 14, the relevant paragraph is at
Tab 14.
and also tab 12. By the
14 is the case of Bundu.
Bundu, yes.
And which paragraph do you want us to look at in this Privy Council judgment?
I may be allowed to take one instruction from.
Yes, of course.
Well, I understand it would be on the second page, and it would be on the 3rd paragraph from the bottom.
Not exceeding 12%.
Not exceeding 12%, but we have included a decision of the industrial court on the, which is at tab 12. Starting with proceedings at page, record at page 683 to 697.
Yes.
Where by the end, the concluding paragraph, the defendant shall pay interest at 12% per annum. And this is the cursus before the industrial court regarding interest.
Yes.
On the issue of, that is liberalité, that is remuneration.
Yes.
Whether it would be 41,000 or 51,000. We have put in the case of Stella Insurance, but there is a slight distinction to be made between Stella Insurance. There, leaves were not computed for the purpose of remuneration. And it is a decision of the Supreme Court in 1987. But what happened in 1993? The PRB report awarded and changed the policy so that leaves, local leaves, were cashable. And we can gather support from respondents' letter in that respect when it proposed to offset at an early stage. And I would invite your Lordship to page.
Which tab is it?
It's in the
No,
record.
it's the record. It is at page 220.
220. Very well.
20. A letter dated 14th of February 1997,
Yes.
where respondent's attorney proposed to make a set-off: sick leave, bank sick leave, etc. But we have also the plea of the appellant, that is, before the industrial court.
Yes.
Trips will bear with me.
What are you looking for, Mr. Tiluk Dari? Let's try and help
Of
you.
the respondent before the industrial court in or about 3rd of April 1997. It is at
We haven't got many of those old documents,
at
have we?
page 179 of the record, my
Oh,
lord.
very well. Thank you. Yes.
And we have to look at same with the plaint, which is at page
54.
page 54 of the brief.
Yes.
That is the items listed at page 54 of the brief at paragraph 2. Monthly salary, commuted traveling allowance, passage assistance, contribution to pension,
Yes.
right? Save and except to E. Most of them have been accepted. And regarding paragraph 3, sick leave, casual leave, vacation leave, save and except for 21 working days, which was denied, the rest has been admitted. And in support, we have the letter dated 14th of February 1997. And so that these entitlements, it is our respectful submission. Car loan, duty-free facility would amount to something that is quantifiable and which would form part of remuneration. If we look at the ratio of the cases of Stella Insurance at tab 37, the case of cargo handling, and the case of S&U Stores versus Lee, 1969, at page 953. That is everything that can be quantified.
Yes.
In the case of S versus Lee, remuneration was not mere payment for work done, but was what the doer expected to get as a result of the work he did, insofar as he expected to get what was quantified in terms of money. That is, these are a reduced rate of housing loan, of rate of interest, could be quantified, and there has been a computation that has been carried out in the plain at page 54 and 55. And it is our respectful submission that those amount to remuneration. And also I will find support in the definition of remuneration under the Labour Act, which has been included at...
I think we can cut this short, Mr.
That is
Kiluk-Darry.
definition section.
We can cut this short. If the Supreme Court hadn't decided this, there would be an issue. But the Supreme Court may have decided it. And that decision may be binding on you. And it may be too late for you to raise this issue. That's what we've got to consider now that we should be ending the case and retiring and deciding what to do about your appeal.
My Lord, I would conclude by ending that the Supreme Court judgment has been quashed, has been voided, when the Privy Council did not make any reservation, proviso, and concluded in saying that the appeal is allowed in all circumstances. Yes. I have done mine.
Well, I'm really grateful to you. In fact, the board is grateful to everybody who's been involved in the preparation of this case. The leaders, obviously, the juniors, the local solicitors, and in particular, well, not in particular, but also the English solicitors. So it's been a combined operation, and it's worked very well, and the video conferencing of Mr. Passem has worked very well, and we've been considerably assisted this morning by everything that's been said, and we will now take time to consider our judgment. Thank you.
Deeply obliged. It's my lady.